global happenings today. We communicate, we analyze global news.
Hello, beautiful people. Welcome back to our channel. Ever since Justice Joyce Malik had made that pronouncement about holding down the allocation of Rivers State, it has attracted a lot of attention. One of such is a senior advocate of Nigeria and a king counsel in the UK, Professor Federalism, have decided to address this matter. This time around, coming from every angle, including international angle to federating unit. Let's quickly look at what he's got to say about the law and interpretation, taking precedence of what had happened in Lagos and even the constitution, and also not forgetting the issue of the legitimacy of the 27 lawmakers. If genuinely the Okojumbo-led assembly is enough for Fubara to have presented the budget for 2024 and what next. Let's find out in a moment. But before we do that, kindly subscribe to our channel. Let's hit the ground running. According to the news, a senior advocate of Nigeria and a King's Counsel in the United Kingdom, UK, Professor Fidelis Odita, has alleged that Justice Joyce Abdul Malik of the Federal High Court sitting in Abuja had demonstrated a fundamental misunderstanding of the federalism's principles by stopping the faac allocation to Rivers State. He argued that the court lacks the constitutional authority to deny Rivers State its faac allocations. Let's find out why he said so. He emphasized that there are differences between Obasanjo's direct seizure of Lagos State local government funds and the current court's that's federal court's interpretation or misinterpretation of the law. He stated that while Obasanjo then attempted to withhold local government funds from Lagos State, he never attempted to seize the state's direct allocation, as this would have been beyond his authority. He also identified that the 2004 Supreme Court decision definitely ruled Obasanjo's actions regarding local government funds as both illegal and unconstitutional, establishing a significant legal precedent in Nigeria's federal system. It's not a dispute between the lawmakers. It's not a dispute between the lawmakers and the governor, he said. The entitlement to receive faac monies every month is very central to the federalism that we operate. It is not possible for Rivers State to be federating unit and not receive faac allocation or money. This is very different from the dispute that Obasanjo had with Governor Tinubu as at that time, where Obasanjo seized the local government money. He did not seize the monies of Lagos State as a whole. He couldn't even seize the monies of the state. He thought he could seize the monies of the local government, but the Supreme Court in 2004 made it very clear that he had no power to do so and that his act was totally illegal and unconstitutional. And of course, the difference between Obasanjo seizing local government funds in Lagos State and the Federal High Court purporting to interpret or misinterpret the law, there's some difference. But clearly, the judge did not understand federalism. She has no power to make that order. Rivers State cannot be a federating state without being entitled to receive that money. Our judges, it looks like, based on what this man is saying, this senior advocate of Nigeria is saying, there needs to be another reorientation, especially for judges and interpretation of the constitution. Let's find out what he's got to say about the issue of the 27 lawmakers that defected, and if it was really legal or legitimate for Fubara to have presented the 2024 budget, and if it was constitutional. Now, according to him, he said that pro-Fubara lawmakers being able to form a quorum has alleged that the operational continuity of a state house of assembly cannot be disrupted merely due to the loss of members, even when the number of departing legislators is substantial. He emphasized that the proper protocol would have been to request the Independent National Electoral Commission, which is INEC, to conduct immediate by-elections to fill the vacant positions. He specifically highlighted the urgency of such elections, suggesting they should be treated as emergency measures to restore full representation in the state legislature. However, Professor Odita made a crucial observation regarding how INEC had failed to conduct these elections to replace the 27 lawmakers. According to him, he said, and I quote, "The State House of Assembly cannot stop functioning because it lost its members or it lost a significant number of its members. I believe that the correct thing for them to do would have been to call for INEC to conduct fresh elections like an emergency election, absolutely to fill those seats. But if INEC refuses for whatever reason, because it's politically partial, or is not independent, or for whatever reason it fails to do so, that cannot prevent the state from functioning." Back up, my colleague is in the house. I really do not know how the lawmakers will take this. Remember, don't also forget that the lawmakers, the same lawmakers or defected lawmakers, had withdrawn that lawsuit, refraining and restraining INEC from conducting election, just to prove that they never defected from PDP to APC. Now, INEC now has the full go-ahead to go ahead and conduct the election. My colleague is in the house. What's your take? Do you think that the judge that made that statement or passed that rule, do you think she may likely retrace her step and begin to look into it, or is it that she did not see a loophole? Because now most senior advocates of Nigeria and even those who practice internationally are beginning to interpret that same constitution that shouldn't have been difficult for the judge to have interpreted. What's your take on all of this drama?
The first thing I said about that court judgment was, whenever emotions are being brought into judiciary, apart from emotion, immediately judiciary become partisan in politics. You're going to see some things that will be laughed at in the future. Some of the jurisprudence we have seen today, or what for this short period of time, some of those antecedents that are going to leave behind will be laughed at in future by most lawyers. Most of them will be questioned, and that was why some people were recommending that the Nigerian Judicial Council, to avoid such future mockery of judiciary, should start reviewing some of the court judgment made by these, in quote, partisan judges. Because from all indication, I know very well that before you get to that level of being a judge, you must have understood very well the principle of federalism. As enshrined in the Constitution, all the provision of the Constitution, you should be in your fingertips. So for that reason, emotions will not come in. But unfortunately, because just like this guy said, Wike is busy building houses for them and doing a lot of things. So by the time he becomes emphatic over things that are totally irrational in law, they will start following the pattern. And tomorrow, some of them will be mocked and ridiculed for ever sitting in such position to make that. When we talk like this, some of the supporters of Wike, they will come and say, are you a lawyer? Are you blah, blah, blah? There are some things that some of us have, at least in our different courses, we have studied law. At least business law, we have an idea of how this thing will be. Okay, apart from it, government now in secondary school, we understand and some of these things, we pick it up and we read thoroughly, we read it deeply, and we get to understand the lines and the concept of these key democratic features, and we make mention of it. Come on, just imagine how an international judge or international lawyer is talking down on a federal judge who should, her own judgment should be a reference point internationally. But today it will be laughed at. Tomorrow, in some of the international faculty of law, when they talk about defective court judgment, such like this will be drawn up, and they will now laugh over it and talk down on it, just as they're talking down and judging our leaders. Must it affect all the arms of government? Come on, it's absolutely wrong. Imagine just these few days we've heard what happened with children, minors, and all of that. And now this is the time that the Chief Justice, Attorney General of the Federation, is now demanding for the fire, bring the fire, blah, blah, blah. Come on. It's everywhere. Come on. And do you think that any right-thinking investor, seeing how you're trampling on the fundamental human right of not just adults, Younger people, you understand, would deem it fit to come and do business with you. These are some of the things that is eroding the values in Nigeria and should be checked. The CGN should do something critical about this thing. Don't allow Wike to make a mess of your system. Whether we like it or not, this Wike, one day he has come. One day his voice will be no more. Whether we like it, won't be in politics, national politics forever. We saw the likes of Rotimi Amechi, we saw the likes of Buhari, they are countless. At one point, they fizzle out. At one point, you will retire. Now, what will be, when they look back at they won't even be blaming him. All fingers will be pointed at you. That when you were judged, what did you do? What was so significant about your stay? These are some of the things that they need to checkmate.
All right, that's a good wrap it up. Let's